They are by far the biggest amount of litigation claims that go into the labour courts.
How would I be in the position to prove that this termination is based on me filing a complaint? Herzlich willkommen auf dem YouTube-Kanal Dubai Recht klar mit Deria und Omar. Heute möchten wir über das lokale Arbeitsrecht sprechen in den VAE und über Arbeitsgerichtsprozesse. Und hierzu haben wir unsere Partnerkanzlei wieder eingeladen mit Darren. Thank you very much for joining this podcast.
Thank you for inviting me.
We are going to discuss some general topics about the labor law, but also about disputes and litigation. Let's start with the first question. What are some common labor law disputes that you can see more and more in the UAE?
That's quite an open question because the UAE is quite unique insofar as it doesn't have one simple system. The majority of the UAE is governed by the UAE federal law, which is law number 33 of 2021, which people are still calling the new labour law, mainly because it replaced the old labour law that had been in place for over 40 years. And then we have systems like the IFC, which has its complete own labour law, which was again amended recently. It came into force in 2019, but it's been amended recently in 2021 also. In both instances, I would argue that the most common complaint revolves around either illegal deductions from somebody's salary coupled with end of service benefit. They are by far the biggest amount of litigation claims that go into the labour courts. There are still claims for unlawful termination, but generally, if those fall under what used to be what we called an Article 120 offence, better known as gross misconduct, and is now an Article 44, this is where an employer terminates the employee instantly without notice. Now, there's a little bit of a misunderstanding still out there, whereby employees are either reading something on the internet or misunderstanding something, whereby they think if they are terminated with notice or even without notice, there's a 3-month compensation that they can claim. Under the previous law, which has been repealed, it's gone, there was a provision that if somebody was terminated for something unrelated to their work, then there was scope to obtain an additional 3 months in compensation. The revised labour law has removed that. There is only one instance in real terms where you can get this enhanced compensation, and that is called for an illegitimate termination. Now, for a termination to be illegitimate, you have to either A, present a claim to the Ministry of Human Resources and be dismissed because of that, or B, you have taken a court case, which is generally a criminal claim, by the way, against your employer, which has subsequently been proven, and you've been terminated because of that. Then you can get the enhanced 3 months. Now, that's only for employees on the mainland or subject to the UAE federal law. DIFC is slightly different. And in DIFC, we're seeing a rise as more and more employees become aware of discrimination claims. For example.
Really? Discrimination claims means what exactly?
Well, both laws, both the federal law and the DIFC law, have now got full provisions for discrimination based on certain protected characteristics, as we like to say in English law. So in the UAE, we have sex, race, disability, national identity, age, maternity, pregnancy, and marriage. Those are protected characteristics, both in the DIFC and in federal law. The difference being, if you are subject to discrimination in the DIFC, you can present a claim to the DIFC and obtain compensation if it's subsequently found to be right. Under federal law, it's a criminal offence. It's not something that you can go to the labour courts and say, I've been discriminated against, give me some money, because there's no provision for that compensation, which is why that illegitimate termination clause is in the labour law. So you would present your racial discrimination or sexual discrimination claim to the appropriate authorities. They would take action against the employer under the penal code. If that's proven and you're dismissed, then you've got the claim for the illegitimate termination. So it's a little bit long-winded under
Yeah.
the federal system rather than the DIFC. But another important thing to note about DIFC, if you have got one of these discrimination claims, the possible compensation includes what we call injury to feeling, which doesn't exist in the federal system. So on the federal system, you have to have proven losses. But in DIFC, it can be injury to feeling, even if you have no loss. So if you're discriminated against but not terminated, you can still be awarded up to 1 year's salary as injury to feeling.
Not bad.
Not bad at all, but don't go out discriminating. It's not a good idea.
I have one question. Let's assume I have been terminated. Before being terminated, I'm going to the Ministry of Mohre, Ministry of Human
Yes.
Resources, and I'm filing a complaint with them for whatsoever reason. Based on that, I'm getting terminated. Me as an employee, because I think that can be one of the challenges under the new law for employees to claim the compensation. So me as an employee, how would I be in the position to prove that this termination is based on me filing a complaint?
That is an incredibly good question because the burden of proof is on the employee. It's not on the employer to prove that you weren't terminated because of this for any other legitimate reason. And it's not as easy as it sounds for an employee to turn up and try to present proof. It is on the balance of probability still. So the employee's got to show 51% that they were terminated for this reason. But in a majority of cases, there may be evidence saying of poor performance or other issues. So it's not an easy hurdle for an employee to jump over. However, circumstantial evidence here is still evidence. The Ministry of Human Resources would say, well, it's a bit of a coincidence that they've raised a claim and then, 2 days later you've been dismissed.
Exactly, yeah.
And they would err on the side of caution. Generally, the presumption is if you're bringing the claim, the presumption is that, well, you're telling the truth.
An interesting case, actually. I think also for clients and future claims, that's a major topic.
And Darren, now we were talking about the claims when it comes to unlawful termination, especially in regards to the new labor law. What do you think in general about the new labor law? Does it grant the employee with more rights, or is it the other way around?
This is something that a lot of people have said to me, that the new labour law is terrible. It takes all rights away. And I wrote an article recently on this, whereby I'm not seeing that myself. The new labour law, realistically, has given us more rights as employees. And, virtually everybody out there is an employee. So the first thing that we've got, which I think is vitally important, we can no longer be terminated instantly without notice during probation. There is now a notice period. This gives employees a little bit more stability because whilst you're on probation, you're not entitled to go on leave. Realistically, you're not entitled to sick leave. And a lot of employees get very upset over this. And we used to see, and there are some sort of nefarious companies out there who will hire somebody, and the moment they get to the end of probation, they will fire them. This notice period has helped that. That's one protection. As I mentioned earlier, we've got discrimination. We also have harassment protections and bullying protections within the law. Now, admittedly, some of those were in the previous law, but in the new law, they are clearly there. And not only are they clear, that they're clearly defined what amounts to bullying and harassment. Even being shouted at in front of colleagues and being demeaned or humiliated could amount to bullying. Now, admittedly, that's not something you can take to the Ministry of Human Resources, but it is something that offers you more protection than what you previously had. Everybody now, regardless how they're terminated, is entitled, if they've qualified for it after 1 year's service, end of service benefits. Now, under the previous law, if you were terminated for a gross misconduct offence, which is this Article 120, you forfeited your end of service. You didn't get it. Now, if you're terminated for a gross misconduct offence, the instant dismissal, you are entitled, regardless, to end of service. So that is another massive protection given to employees. And one of the biggest ones that everybody forgets, we now have different methodologies of working. So when I first came to the UAE, you could only work for one employer. If you work for a second employer, even if it was only for an hour, you were moonlighting. That was illegal. You could be facing serious sanctions. Now we've got the ability to work part-time. Admittedly, you still have to have 2 work permits, but you're no longer restricted. I personally have 2 jobs. I work full-time as a lawyer for Hussein Luta, and then on certain days of the week, I am a part-time law lecturer for one of the universities here. I have a work permit for both. Prior to the change in the law, I wouldn't have been able to be a part-time law lecturer. Not only that, we have now introduced flexible working time. Now, that's mentioned in the UAE law, but it is between the employer and the employee. Now, under the previous regime, you had to start at 7:30 and you had to finish at 5:30. Now, it's free for the employer and the employee to mutually agree when they come in leave, which is not a bad thing. It's not just a throwover from COVID, by the way. This is something that the UAE government has seriously looked into and said workers are more productive if they're given this flexibility. It allows people with childcare responsibilities, taking their kids to school
Yes.
or picking them up and stuff like that. And then we have the very last part, really, which is now we have seasonal contracts. Previously, you couldn't bring somebody in. You had to bring them on a fixed-term contract. Okay, and all contracts now are fixed-term, and I'll get to that in a moment because that's one thing that everybody's complained about. You used to have to bring people in on fixed-term contracts, and let's say you're Global Village, okay? If you let them go too early, they could claim in the courts for the remainder of the fixed term, which was really unfair, especially if they'd done something wrong or something had happened. Now, with the seasonal contracts that we have, all these temporary contracts, the people at Global Village, because it's only open for a few months of the year, they can now bring in people on these flexible contracts effectively without fear of either party having a problem. Now, quickly turning to the change of the unlimited contract, this is a misunderstanding. When the law first changed, it abolished unlimited contracts, which was seen as part and parcel of the way things worked. And the reason we had unlimited contracts was because the only other contract was fixed term. And as I said, if you terminated fixed term before the term expired, the other party was entitled to a lot of compensation. When they first brought it out, they said that a fixed-term contract was restricted to no more than 3 years. And if you still go onto the internet and download the labour law, it still states that. That is incorrect. They changed the labour law about 2 months after they issued the law and removed that 3-year requirement. Now the law is every contract must be fixed term, but there's no fixed duration. So if I put you on a 10-year contract, it's still a fixed term contract. Now, the reason they did it was to try and coincide with visas. And it changed because the visa system changed. Because now we have green visas, golden visas, and potentially blue visas. Whilst it appears, whilst it's correct that unlimited contracts have gone, that is true, it's not as onerous as people think. It's not, I'm only going to be employed for 3 years. You can be employed for 5 years, 7 years, 10 years. It depends.
If we see this now more from employer side, Darren, because we were talking a lot about employees' perspective. If I'm an employer and want to hire somebody, and then obviously I need to draft an employment contract, what are the essential topics an employer needs to take care of?
It's quite interesting because in certain parts, for example, if you are an employer in the free zone, one of the free zones, and let's take DMCC as a prime example, you will have a fixed contract issued by DMCC. And a lot of people think, oh, that's it, I have to have that contract. That's not actually true. You are entitled to issue your own standard bespoke contract as long as it doesn't remove the rights within the DMCC contract. A lot of people don't realise that. The other thing a lot of people don't realise is that the law only sets the minimums, not the maximums. You can increase things with the exception of the notice period, which is limited to 3 months. The law's minimum is 30 days, but there is a maximum of only 3 months. So the first thing that employers need to work out is, firstly, one, how are we going to pay the employees? Almost everybody now, with the exception of a few free zones, are paid via the wages protection system. So it's vitally important that the employers know how are we going to pay the employees, when are we going to pay them, and what does that payment look like? Are we breaking it up like we used to into basic salary, accommodation and transport allowances, or are we giving just one package nowadays? Hours of work is another important area because the UAE does have a minimum working hours, just like the European Union, and 48 hours is what it is. Now, unlike the European Union, there's no opt-out, so you can't take your employees and say, are you opting out of the minimum working time directive? Here, there is no opt-out, but there is overtime. And employers need to realise that overtime can and will apply to certain classes of employees. It may not apply to certain shift workers or managers or those in a supervisory role, but everybody else it will do. And they are legally entitled to this. And that's where one of the claims lies. People are taking claims because they're not being paid. They need to be crystal clear in their employment contracts what the employees are becoming more and more enlightened as to their legal rights in the UAE. The employment laws are all over social media. Everybody can now access them, unlike previously. They're all in English now. Unlike previously, where most of them were only in Arabic. So employees are becoming more and more aware of their rights. Therefore, the employers need to make sure their contracts are in full compliance with the law, because employees will take action. It's as simple as that. The employer also needs to realize that there's two parts to a contract. There's the offer and then the actual contract. If they make an offer and it's accepted, and then that changes by the time it gets to the contract, that may also give rise to a claim, because it's a breach of promise.
Yeah.
And they may end up going to the Ministry of Human Resources for that also. By all means, take the standard template that the governments give or the authorities give in the applicable free zones or from the Ministry of Human Resources. Take that as your template, add to it if you wish, but always make sure that you are complying fully with the law. It's as simple as that.
You were talking about old law, old labor law, and the new labor law. Can you also give us some ideas about what actually changed from the old law to the new labor law?
Well, the old law went to something like, I can't remember now, about 160 articles, where the new law is only about 60 articles. So 100 articles have disappeared somewhere. One of the things that the old law stated was that you had to employ a national before you employed anybody else. So there was this perception that there were two laws in place, one for Emiratis and one for everybody else, which was an incorrect perception. What they did with the new law, they removed that, so that article no longer exists, and they replaced it with Emiratiization, which is a completely separate law. They also brought in more clarification on what employers have to abide by. So, for example, if you are going to discipline an employee as an employer, you really must have a disciplinary procedure. Now, the law doesn't stipulate you must have a procedure. What it does state is if you're going to deduct somebody's wages for something, there must be a hearing, there must be an investigation, the employee must be able to put their version of events before you do something. That implies there needs to be a disciplinary procedure. Other parts of the law also imply you need, as an employer, to consider having a grievance procedure. Now, if you have a grievance procedure, you are giving the employee the option to come and raise complaints to you before it escalates to the Ministry of Human Resources. And again, whilst it is not expressly mentioned in the law, there are parts of the law that sort of imply that these two policies would be very good to have in place. And I would strongly advise all employers to really consider having either an employee handbook or an HR policy whereby these things are quite clear, because you're better off preventing the problems now than trying to face them at a later date when somebody does bring a claim. The other thing, and I know it's not part of the new labour law, but another aspect that employers need to consider is the following. Under the old law, almost every case went to the Ministry of Human Resources courts. This year they introduced a new system. Anything below 50,000 dirhams is no longer handled with mediation or a court case. It is handled internally by the Ministry of Human Resources. And they promise, and I don't know if it's true or not as of yet, seems to be the case, that they will issue their determination within 3 days. So if an employee has got a claim less than 50,000 and they put the complaint in, the Ministry of Human Resources would probably ask the employer, give me your version, and then based on those two documents, they will come up with a decision. It is fast-tracking the system massively. I don't know how successful it is. It's certainly freed up the courts, and it's allowed the courts to focus on the bigger aspects and the bigger claims. But employers need to really understand this. It doesn't cost an employee to present a claim less than 100,000. Less than 50,000, not only is it free, but it's fast-tracked as well. So it's better for employers to have these preventative measures in place to prevent these claims hitting them at a later date when they least expect it.
How can I, as an employer, ensure that my employment agreements are compliant with UAE labor law? What would you say?
By hiring a lawyer, right?
Yeah, that's exactly what I would say. I'll be honest with you. A lot of companies, a lot of clients, and a lot of employers don't like to do this because they feel that they're spending unnecessary money. Every client, no, it doesn't matter what field it is, they don't want to come to a lawyer early because they think, I'm spending money and I haven't got a claim. My argument is, surely you would rather spend, 5,000, 10,000 dirhams now than spend 500,000 dirhams at a later date. And this is the thing. Remember that when you speak to a lawyer on this preventative side, whilst you may not see any realistic, tangible cash coming in, as in you haven't won a case, so you're not bringing that money in, it's intangible, but you are saving considerable amount of money. If you have a lawyer go through and tick box your employment contract, that will be a template for all your employees.
Exactly.
And it's not just applicable to one employee. It's the same as if you engage a lawyer to help you write your HR policies and procedures, that's a one-size-fits-all. It only needs to be updated when the law changes.
Yes.
You're saving considerable money in the long term because litigation is not cheap. It doesn't matter where you are in the world. If you're in Europe, if you're in the UAE, it's never cheap. And you're the employer. Unfortunately, you've got deep pockets. And when you come and say, dear Mr. Lawyer, I'm being sued by my employee, he says, oh, okay, we can do it for X amount of money.
Yeah.
It's that straightforward. You're better off being in a position whereby you go to the lawyer and say, can you stop this from happening? Now, we can't guarantee that nobody will ever sue you. That can never happen. People want their day in court in some instances. You know, people feel aggrieved and it's very personal to them. But what you can do is reduce your risk and have your defense. And as I say to a lot of presentations that I do, it's better in the legal field to have a shield rather than a sword. Yeah. And this is what we're saying here to prospective clients. Get your shield in place. You're better off that way rather than wielding your short sword at a later date.
Yeah.
Because when we see all the movies of the Middle Ages, swords go everywhere, where the shield is very straightforward.
Thank you to you all. I think we had a very, very interesting session on the employment matters in the UAE. Wenn euch das Video gefallen hat, gebt uns gerne ein Like, kommentiert, abonniert den Kanal und wenn ihr Fragen zum VAE-Recht habt oder eine Firma gründen möchtet, dann meldet euch gerne bei uns.